This is Colin O'Keefe for LXBN TV. It was announced last week that the Department of Justice had done what some would deem the unthinkable and secretly obtained phone records for 20 Associated Press reporters in an effort to root out a source. Joining me to break down the story and share his thoughts on it is Jeff Kosseff, a former professional journalist and Pulitzer Prize finalist, now an attorney with Covington Burling, where he's an author on their blog, InsidePrivacy. Jeff, first, in your experience as a journalist, just how crucial are anonymous sources, and why is what happened here so egregious?
Well, I can't imagine investigative journalism occurring without anonymous sources, because if you really want to get beyond what government agencies and corporations say in press releases, you really need to go to people who have information that, frankly, they aren't necessarily supposed to give. And this is, the vast majority of the time, anonymous sources aren't breaking the law, but they might be violating employment policies. Their employers might just get very angry that they're providing you information. So these people have a lot to risk with their jobs. They could be sued. So anonymity is so important because they won't provide the information to journalists unless they can be guaranteed anonymity. And so in the United States, the way that it's worked for decades, if not centuries, is journalists will obtain information, have discussions with anonymous sources in exchange for a promise that the journalists will not reveal their identity. And I mean, it's a trust system. It's not a perfect system because the sources have to trust the journalists, and the journalists, if they're subpoenaed to go to court, they can fight the subpoena, but really, I mean, they can face jail time if the court decides that they have to reveal their sources. And in fact, there have been a number of journalists who have gone to jail rather than naming their sources. So again, the system isn't perfect. It would be great if there wasn't the prospect of having to face jail to protect your sources, but that's how it's worked, and that's why the news about the AP kind of shocked that system, because what this means for journalists is that you can't promise confidentiality to your sources, absolutely, because even if you are willing to go to jail or pay heavy fines, there's still the chance that the government can find the information through alternative means without even notifying the journalist in advance. So then the journalist and the news organization doesn't have an opportunity to challenge that in court.
Absolutely. It seems very disruptive in a way that prevents people from being watchdogs, from being whistleblowers. It really disrupts the...
I should probably add that in the specific case of the AP, we don't really know exactly what happened because there are a lot of details that haven't been released and that probably for national security reasons won't be released. So we don't quite know the mechanisms that were used, but just what's been startling for journalists is just the fact that this could happen.
Absolutely. It's really a shock to the system, more or less. So second, you wrote that the First Amendment and really the Constitution as a whole are only as strong as the government behind it. So what do you think must be done then to protect journalists and their sources?
Well, I think the best first step is a federal shield law. The way that this works is that 49 states and the District of Columbia have laws called shield laws. And what these do is they set limits on subpoenas for information about confidential sources from journalists, both in criminal cases and in civil cases. And they say very few are absolute. The vast majority have balancing tests, or they say in certain types of cases, reporters can't be required to give their sources. But all of these states have them. The federal government, on the other hand, does not yet have a shield law. It came very close to passing one in 2009, and it's been reintroduced this week in light of the AP news, and the Obama administration has reaffirmed its support for the shield law. So that's really the best step, because that at least gives some certainty to journalists that they know in these situations they won't be required to reveal their sources. It's not going to apply in all situations. We don't know whether it would have applied in the AP because, as I said, we don't know all of the details of it. But at least what this does is it gives a baseline of expectations. And the most important thing about shield laws is it gets judges involved in making these determinations, because as we saw in AP, what's going on right now at the federal level is a lot of these determinations are left up to the Department of Justice. And so the great thing about the shield law is that it gets a judge to come in and review these decisions, and with a totally independent perspective, nothing to gain from either approving it or not allowing it. And I mean, that's what our justice system is about, especially when it comes down to these crucial First Amendment questions. You want the independent judiciary to be the watchdog, to make sure that the media's rights are not being violated.
Absolutely. The media and journalists are an essential part of our democracy. And it's going to be interesting to see what more does come out on this. You mentioned that it's very possible that nothing else does come out, but it'll be interesting to see if these subpoenas were necessary and to see why they were used and why the government wanted these phone records so badly. Once again, that was Jeff Kosseff of Covington and Burling. For more of his insight on this story, be sure to visit InsidePrivacy.com and be sure to visit LXBN.com for hundreds of these LXBN TV video interviews, along with curated commentary from the Lex Blog Network's more than 8,000 members. Thanks for joining me today, Jeff.
Thanks very much.